Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we are on the part 3 of our very special series on the Bhartiya Nyaya Sanhita, Bhartiya Nagarik Suraksha Sanhita, and Bhartiya Sakshya Adhiniyam. And we are going to discuss the highlights of these 3 laws which were implemented only recently and what are the developments in terms of use of technology, also use of newer methods of investigation, and a lot more. I have a panel of experts who would be better able to opine on these issues. Let me welcome Senior Advocate Percival Bilimoria. I have with me Advocate Shashank Garg. Manmit Singh, partner with Saraf and Partners, also joins us. Good to see all 3 of you. At the outset, let me request Senior Advocate Percival Bilimoria to make an opening comment and then we follow. Over to you, Mr. Bilimoria.
Thank you, Tarun. I'm really glad that you've taken up this topic. There's a lot of misinformation floating around. I, for one, believe that these laws, and we may be a little wistful about it because ever since we started practice, these are the laws that we've been used to. And now, as Mr. Chidambaram has said, that we'll have to look at some kind of a table to see what is the old provision and a new provision. But quite apart from that, I think these new laws are revolutionary. They, first of all, fold in a lot of provisions which are court decisions, so authorities. I mean, the courts have ruled on several points of law over the last more than 100 years. And many of these concepts have been folded into the law to start with. So the jurisdiction, the jurisprudence has been, in a way, incorporated into the statute, which is a very good thing. There are some modern practices such as, mandating forensic investigation. Of course, there'll have to be a lot of capacity building for this. But, I don't see how these laws can be seen to be retrograde in the first place. I think, some of the criticism that has been leveled against these laws is a little, hard to swallow, if you ask me.
Point very well taken. Thank you for the opening comment. We'll go to Advocate Shashank Garg for his first intervention.
Thank you, Tarun. I would fully agree with what Percy has said. I think these 3 set of new laws are, one, of course, modern. They are sensitive to the needs of the Indian society. And they, of course, would provide for efficient justice delivery system. So overall, of course, there are small criticisms like what Percy was mentioning. We may take some time, the judiciary may take some time, so would the investigation officers would take a little bit of time to get around these provisions. But if you look at the scheme, these have been designed to take into account the modern India's legal problems on the criminal side. So, of course, the most recent law from the older regime is of 1973, already 51-year-old. That's a procedure law. But if you look at IPC and Indian Evidence Act, over 160-year-old laws. So they were, of course, very comprehensive at the time they were brought in, but they cannot continue to hold the ground for India. So these 3 new laws that we now have will certainly aid in better delivery system of justice in the country.
Point well taken. I'll go to Manmit Singh, partner with Saraf and Partners, for his opening comment.
Tarun, thanks for having me on your show. I couldn't agree more with Percy and Shashank's opening comments. I think the time had come to incorporate developments in technology. And also, as Percy said, criminal jurisprudence was spread not just between the 3 statutes, but also a plethora of case laws. Those had to necessarily be folded in to make it easier for not just practitioners, but even for ordinary people to know what their rights were. And I think what is important is that we have always looked at criminal laws as being central to the being accused centric. The right of an accused must be protected. But it's the first time that we are also looking, without giving up protection of rights of accused, we are also looking at the rights of a victim. I think that's very important. We have looked at the new laws look at new offenses such as mob lynching, etc. These are new offenses which have been brought in, which were required. There were Supreme Court directions saying that the government must frame a law with respect to these offenses. The new laws also incorporate technology in a way which was not there before. So I think change is the only constant. Change is always difficult, but we must embrace change. And I think that's what these laws seek to do.
Point well taken. I'm going to now highlight a few changes that have been brought in the new laws, and we'll take comments from each of our panelists. There is this thing about reporting incidents online, wherein people can now go and report incidents by electronic communication on a website. They don't need to visit a police station. This in many cases will be helpful for the common people and everyone. If there is a theft or any other issue, the issue of filing FIR at any police station across India is as equally important. You can file a FIR at any police station in India for any jurisdiction. This was not possible earlier. We knew of instances where the police would direct the complainant to go to that particular police station and file, and it was a hassle for a lot of people. Free copy of FIR seems a small little development, but goes a long way. And the good thing is about right to inform after arrest. If a person has been arrested, he has a choice to inform a person of his choice, and the police will assist him in that activity of informing, because of course he would need some legal assistance. We'll go to Senior Advocate Percival Bilimoria for his comments on these changes and more. Over to you, Mr. Bilimoria.
Yeah, so Tarun, some of what you mentioned had already been part of the jurisprudence. So, for example, there was a case of Paramveer Saini, which pretty much said what you just mentioned. But I think the biggest thing is what Manmit mentioned, that I think for the first time we are seeing the right of the informant or the complainant, because the informant or the complainant is also considered to be an equal stakeholder in the proceedings. I think that's a very major, somewhat philosophical change here. And there are 2-3 very big changes here which one needs to note. So, the provision on sedition, as you know, was very controversial. I'll just touch upon that. So it is true that there is another alternative provision mentioning more or less the same provision that was there on sedition. But there's one very fundamental change here. See, the old provision of sedition is a vestige of the British Raj. That provision dealt with any kind of hate mongering on the government. Right now, this provision that is substituted talks about the country, the nation. So if you are going to talk about inciting hate against India, propagating the breakup of India, then that is the real meaning of sedition. And the most important thing, people are always pointing out, this is similar. But I'm sorry, it is not similar, because there's been a very major change here. Instead of the government of the day, it is talking about the nation as a whole. And I think that's a very important thing that has slipped people's minds. It's loosely known as treason, but the title of that provision is not treason. It's different. Then the other provision that was mentioned by Manmit, which is mob lynching. Right, and one of the regular criticisms that has been leveled against this government is, this lynching thing, which now you have a law introduced by the same government, which says that any death that occurs, or even grievous harm that is caused by a mob of 5 people or more, is punishable very severely if that is on the grounds of sex. It doesn't mention religion importantly, but it says community, race, caste, language, and personal belief. Right. So it's a very wide coverage, and you can't have lawlessness like this on the roads. And I think this law has gone to great lengths to bring in both equity and protecting both the accused as well as I don't believe that there's any dilution of the rights of the accused. And that's a very important point.
I'll go back to one earlier comment you made in your first intervention, Mr. Bilimoria, was forensic evidence collection that also includes videography. It's mandatory for forensic experts to visit the crime scene. Videography will prevent tampering of evidence. These are all very unknown investigative methods to India, because we know that crime scenes have been trampled with people walk, protests happen, all of these things have been happening. But at least in law now, these changes, which means that every police station will have an attached unit of experts that will come. Do you think that criminal... Yeah.
I'm sorry. So again, that's also the current law, but it's not been, which is said by the courts. See, our courts have gone to great lengths based on the fundamental principle, Article 21, right to life and liberty. Right? The rule, the famous rule that bail is the norm, right? And jail is the exception. So I think our courts have really, no matter what the law may be, our courts have stepped in at the right time. So we don't need to worry about it. What this law does is that it brings in a revolutionary change in the manner of investigation. Some people say that, look, the police have extraordinary rights under this law, right? But at the same time, important safeguards have been brought in. So when you talk about videography, the statement of an accused has to be videographed. That's a very major change, right? And the idea of the change is, of course, see, historically, the statement of an accused in police custody is not admissible evidence. And that is because I think the law recognized that, there was intimidation, physical as well as mental or emotional when recording. And therefore, there was this safeguard, right? And so now there's an even more important sea change that, whatever he's saying will have to be on video. There's videographic evidence.
Point well taken. I'll now take this to Advocate Shashank. There is this whole point about limited adjournments. Courts grant a maximum of 2 adjournments to avoid unnecessary delays in case hearings. How will this work out in real life?
See, I'll draw a parallel from what we saw in the Arbitration Act, when in 2015 amendments were being brought in and timelines were being introduced. Everybody thought it's a very overzealous sort of an amendment, and we will see more defiance than compliance of it. And now, within the last 8 years, we have seen that it has disciplined the way arbitrations were happening in this country. Of course, there is a lot more that requires to be done in that regard. I'm very sure that this is going to be a very welcome change. Of course, we have to enhance and upgrade our infrastructure, not just of the police machinery, but also of the magistrates and judicial officers who, have to take care of the criminal trial throughout. But I don't think that we will face a lot of difficulty in compliance of these changes. I just wanted to add something to what Percy has said. There is addition of 2 new concepts of crime, terrorism as well as organized crime, which were not found in the IPC. And we all know that there are several cases of terrorism and organized crime that we have witnessed in the past 60, 70 years from independence. So this is a very, very significant change. There is an approach of the new law seems to be to enhance public safety. If you even look at, there is a section for 106(2), which ensures that if anybody escapes after causing an accident or death by rash and negligent driving, that person would be punished up to a term of 10 years. So that also enhances what everybody has been talking about, the way these accident cases used to take place. Of course, there is some hue and cry. There is a problem with that. The truck drivers and the association has, for the time being, been able to convince the government to put it in abeyance because they had their own set of issues. But just if you look at the approach is to enhance public safety. And something that was touched upon by Manmit is right of victims. First time you see that, what the Supreme Court through various judgments have stated, has now been incorporated through legal provisions. For example, under Section 193 of BNSS, it is now an obligation of the police to inform the victim of the progress of the case, which used to be, the victims or the family of victims would chase the police stations and would go to the IOs with no obligation whatsoever. They would never get any response. Now that is a mandatory provision. So is to supply a copy of all the relevant documents under Section 230. Then victim compensation schemes have been introduced, are now part of the law, which were not there previously. And so is the witness protection scheme, has also been made part of the law. So several significant changes, which shows that the focus was to enhance public safety. And of course, various provisions also touch upon the reformative state of mind of the legislature. We can discuss this, a little later.
Point very well taken. I'll add two more things. We'll go to Advocate Manmit Singh from Saraf and Partners. Community service, or the Indian concept of seva, where for minor offences you can do seva or community service, and in a sense, that would be your sentence. You would not be jailed. How would that work out? I'll go to Manmit Singh to ask more.
Yeah, so community service has been introduced for petty offences, and I think this is in sync with what we see in the rest of the world. We all know that, there are petty thefts, which sometimes, somebody may resort to I remember a colleague of mine had written a poem about how, when he was a former colleague of mine, about how he was sitting as a judge, required to write the judgment in a case of a poor man who had stolen something to buy food for himself, right? So, and putting a person like that behind jail for a petty offense, which can easily be resolved by way of community service. We do have all sorts of societal challenges in India. I think those will, to some extent, those are cases which require to be viewed differently in a reformative sense, and community service will go a long way. I think we've all discussed, the panelists here have discussed about how the laws seek to also protect and prioritize the rights of the victim. But equally, I think the rights of the accused have also been better protected in the new regime. I will cite a few examples. Like, for instance, now the name of the arrested person has to be displayed in every police station. I think this is a small change, but this goes a long way, because earlier it could very well be, it may not have happened in the cities and the metropolitan cities, but in the hinterland of India, a person goes missing, the family does not even know where he is. There is no way to figure out. Now, every police station has to disclose the names of the person who have been arrested. If a person is arrested outside of his normal place of residence, then information has to be given to the designated officer in that district, as well as the district where the person is ordinarily resident. So these are small changes which go a long way to protect the rights of persons who are accused, who are arrested. Then a compulsory audio visual recording of search seizure, including drawing up of the list of things seized, as well as signatures of witnesses. We've all heard of cases where there have been accusations that materials have been planted by errant officers, including under the NDPS Act. All those things we've all heard of. So here is a way where technology is being introduced, not just to protect the rights of the victim. Of course, if you do a forensic of the crime scene, then it'll certainly go a long way in the trial process, but also protecting the rights of the accused, so that if somebody is falsely accused, that will therefore then come out. And we've all heard of, all of these managed search and seizures. Then if in case of a cognizable offense, there is no investigation, now the report has to be sent on a periodic basis to the magistrate. So I can cite any number of examples where even the accused are better protected under the new statutes.
Point very well taken. I'll go to Senior Advocate Percival Bilimoria on the point on timely completion of investigation within 2 months of recording the information. How will this pan out in real sense? Because they are saying that for crimes committed against women and children, 2 months is the time to complete the investigation. Do you think this also is a marked change in these new laws? You're not audible.
Yes, sorry, Tarun. Yes, absolutely. I think, certain timelines that have been laid down in the new law, and you just mentioned one by way of example, is a very good provision to introduce. And, there's also this provision that no more than 2 adjournments. Now, I think it might be, as Shashank mentioned, it's made a sea change in the arbitration law. I think it will in this as well. And I think one of the major criticisms that people have had about the old colonial laws is that, that Tariq pe Tariq syndrome. And this will definitely go a very long way. So, Tarun, there's just one more very important angle that I want to mention, the concept of separation. Separation of a trial, it occurs when out of, say, several accused, one accused is not there. Means he's fled the country, right? And the maxim that is generally followed is that no man can be convicted in his absence, right? Now, the difficulty is that, as you know, we have a lot of cases where people just don't show up, right? And there have been situations where I know for a fact that some foreign people have been advised that, look, it's better that you don't come and participate in this process at all. And then what happens is that the trial just languishes. Now there is a provision that says that, this will not apply. And I really do not believe that this is trampling on the rights of any accused, because the whole principle of criminal law is a fair trial. But how is a trial fair when it is parked, right? And this goes down to the whole question of, the victim. So suppose there is a person who's accused, right? And the person just disappears. He just decamps. Forget about economic offenses. Let's take murder or theft. And then because he's not there, the trial is separated and it just languishes. What happens to the right of the victim? So I think these are some historical issues that have been redressed in this new provisions.
Okay, point well taken. I'll go to Advocate Shashank Garg. One thing that I have in my mind is about electronic serving of summons. It says that it can be served electronically. This means that summons will be WhatsApped to a person, emailed. How does this work? Because, these days people have 4455 email addresses, sometimes multiple phones. If you could explain, how will this work in reality?
Yes, absolutely. One of the examples that you have taken, WhatsApp is going to be one such mode which would be widely used to deliver summons. Otherwise, we have seen, in a classic case, any criminal lawyer from a client would get a call that somebody's at my doorstep to serve me the summons, and the advice would be, don't take it. And then it goes on. So all of that mystery will be solved now. There will be no such option. You could serve all these documents. In fact, I mentioned to you, even Section 230 and 231 of BNSS permits the investigating authority to supply documents by electronic means. There's no requirement to supply a copy of the FIR or the case file or anything in physical mode anymore. I mean, our courts have obviously, whatever we see around, have adapted to technology very, very fast. It is certainly a bit challenging for the police machinery throughout the country. And that's where the states would also have to take steps to upgrade the technical know-how of their officers by, training them to be in sync with the new modern laws that have been brought in the criminal jurisprudence. One aspect, if I can just share, which I think we possibly touched upon but had parked, was an approach to ensure that there is no overcrowding in jails. Concepts like plea bargaining are now time bound under the new regime. First-time offenders, the courts have now the discretion to award them 1/4 or 1/6 of the sentence that is prescribed under the Act. So if you are a first-time offender, you could be let off with 1/4 or 1/6 of the sentence that the Act provides. Under trial prisoners, if you have served 1/3 of the sentence that you're, in case you're convicted, you're likely to get, you would be out on bail. So some of these measures will certainly have a very, very positive impact and will reduce overcrowding of jails, which is a massive issue we are facing in this country. For example which Manmeet gave, a petty theft of 100 rupees, 200 rupees, or just stealing maybe a couple of bananas or mangoes. Everything used to go through the same rigors of a trial, and people would languish in jails for months and years. I think all of that will be taken care of with the introduction of these provisions.
Two important points you shared with the viewers, Shashank. Thank you. I'll go to Advocate Manmit Singh for Saraf and Partners. Recording of statements in a crime involving women should be done by a woman, and that to a woman magistrate. How that will play out? You think that helps? It will apply to all cases, including business disputes and other matters, or this only for criminal matters in this case?
No, this would be for criminal matters, but I think there's no doubt that women and children have also been a focus area of reform under the new laws. You were mentioning earlier about how under Section 193, the time-bound nature of investigation has been prescribed. And any supplementary charge sheet also has to be completed within 90 days. And if it is not completed within 90 days, then you need permission of the court. And certainly new punishments, for instance, for any gang rape of minor, there is death penalty which has been prescribed. So women and children certainly have been a core area of legislative concern on how do we better protect the rights of these two constituencies. I would also like to add to Shashank's point about bail for an under trial where 1/3 of the maximum punishment has been served. Now it will be the duty of the superintendent of jail for filing a bail application. A lot of these under trials, unaware of their rights, would keep languishing. Not only has the period been reduced to first timers to 1/3, but also the duty has been cast upon the superintendent of jail to file this bail application. So I think whichever way you look at this, whether it's the rights of women and children, whether it's the rights of victims in general, whether it's the rights of even the accused persons, this is certainly a very progressive step in India's criminal jurisprudence.
Okay, point very well taken. In fact, appreciate all inputs of Senior Advocate Percival Bulimoria, Advocate Shashank, Manmit Singh, partner from Saraf and Partners, on this series on the Bhartiya Nyaya Sanhita, Bhartiya Nagarik Suraksha Sanhita, and Bhartiya Sakshya Adhiniyam. In our next upcoming show, where I would request all of you to come, we will focus on the specific aspects, like forensic is a very big sea change which requires maybe thousands of crores in terms of infrastructure push. If we consider all the 30 states, because the laws are implemented in all these states, what would they need? What kind of budgets are coming? All of that and more in the upcoming series. But this was just to apprise you of the sea change that these three laws have brought in. And I would like to thank each one of you for making time and contributing to this show. Thank you so very much.
Thank you, Tarun.
Thank you, Tarun.
Thank you.